most trials, is permitted when someone is reporting the direct admission of a crime. Prosecutors brought similar testimony against Eccles. Two teenage girls said in court that while walking around at a softball game, they'd heard Eccles say he had killed the children. Yet there was still this question, why? Why did Eccles and Baldwin kill 3 kids, especially when there was no evidence that they had known or even met the victims? Though not required to, the prosecutors felt they had to present evidence of motive. To set the stage, Fogelman noted for the record that the murders occurred on the night of a full moon. He presented evidence that Eccles read books by the likes of Stephen King, Anne Rice, and Dean Koontz, that he was known to have worn a black trench coat even on summer days, that police had found the skull of a dog and a book titled Never on a Broomstick in Eccles' room. On top of that, they'd found 11 black T-shirts in Eccles' closet. In Baldwin's closet. Fogelman then called to the stand one Dr. Dale Griffiths, a self-proclaimed cult expert, in an attempt to prove that the murders were committed as part of a satanic ritual. Defense attorneys quickly established that Griffiths' PhD was a fraud obtained from a mail-order diploma mill that has since gone out of business. Remarkably, Judge David Burnett, now an Arkansas state senator, ruled that Griffiths could testify as an expert in the occult. Fogelman asked Griffiths if he had personally observed young people involved in the occult. Griffiths answered yes, that in fact he had seen them, quote, wearing black fingernails, having their hair painted black, wearing black T-shirts, black dungarees, that type of thing. He added, sometimes they will tattoo themselves. Remember, this was at a trial in Jonesboro in 1994. Defense attorneys established that there was no physical evidence, candle wax, pentagrams, altars, or anything suggestive of the occult found near the bodies. But Griffiths maintained that the full moon and even the number of the victims, 3, lent the murders occult overtones. In his closing remarks, Fogelman asked jurors to sentence both defendants to death. Pointing to Eccles, he said, "You see inside that person, and there's not a soul in there." In 1996, the Arkansas Supreme Court unanimously affirmed both convictions. In their ruling, the justices cited 11 points raised by Griffiths. In sum, the court concluded, Dr. Griffiths testified there was significant evidence of satanic ritual killings. By the time the 3 lost their direct appeals, Eccles, Baldwin, and Miss Kelly had already been imprisoned for 3 years. I'd like to ask you to think of where you were in 1993 when they were arrested. Think of how much life you have lived since then. I interviewed the men in prison many times. I saw them grow from dazed teenagers to stoic men in their mid-30s. Miss Kelly, who's a little guy, started out a brawler. Over the years, he learned to avoid fights by not getting mixed up with what he called the nonsense of other inmates. He worked in the prison laundry, kept to himself, and had a good record. Baldwin, who was arrested at the end of his junior year of high school, was given some of the most responsible jobs at his prison, both as a counselor and school administrator. He was respectful and he was respected by inmates and staff alike. He longed to catch up on computers. Eccles spent almost 24 hours a day, every day, in a concrete and steel cell, 11 feet long, 7.5 feet wide. A reader before his arrest, a fact that helped to convict him. In prison, he read thousands of books. He also wrote and had published an autobiography and book of poetry. Not a book, but poetry. Since 1996, when HBO aired its first documentary about the case, astonishment over its lack of evidence spread. Celebrities and ordinary people in the United States and throughout the world contributed thousands in fact millions of dollars, for appeals. Eddie Vedder of Pearl Jam, Natalie Maines of the Dixie Chicks, Johnny Depp and others packed a Little Rock auditorium in August of 2010 on behalf of the West Memphis three convicted child killers. But money and good lawyers alone could not budge the Arkansas courts. Judge Burnett, who continued to rule on the case and various pleas that were brought before him for most of the ensuing years, and Attorney General Dustin McDaniel resisted all pleas for new trials. At various hearings, some of the best forensic scientists in the country testified that wounds the Arkansas Crime Lab had attributed to a knife were more likely caused by animals in the canal where the bodies were submerged. McDaniel was not swayed. When evidence emerged that the foreman at the second trial engaged in serious juror misconduct, evidence that McDaniel does not dispute, he resisted new trials. When DNA tests revealed that a hair inside a knot used on one of the boys was from the stepfather of another of the victims, McDaniel still resisted, even though no fingerprints, no DNA were ever found that pointed to the three in prison. No physical evidence has ever been found that pointed to the three. By the middle of last year, Baldwin, Eccles, and Miss Kelly all had appeals pending before the Arkansas State Supreme Court. Last November, 2 months after the star-studded concert, the High Court ruled that under Arkansas law, the three might be eligible for new trials since none of their DNA was found at the scene. It ordered the circuit court to hold an evidentiary hearing at which prosecutors and defense attorneys alike could present all evidence that had accumulated in the case, evidence that was presented at the trials and evidence that had turned up since. Judge Laser was assigned to officiate. His job was to determine if the men, by then known as the West Memphis Three, presented compelling evidence that a new jury, having heard everything in this day, would acquit them. As recently as 6 weeks ago, many of us were anxious to see what evidence the state would present to support executing Eccles and keeping Baldwin and Miss Kelly in prison. Obviously, the state's attorneys were expected to reintroduce what McDaniel has called the confessions, Miss Kelly's to police, Baldwin's to the jailhouse snitch, and Eccles to the softball girls. But then what? Would the prosecutor and attorney general produce those long-rumored damning files? Would they rely on those microscopically similar fibers? Would they argue that the lake knife produced the victim's wound rather than raccoons and turtles? Would they bring back Dr. Dale Griffiths or someone like him to testify about the occult? And what would they make of the stepfather's hair discovered in one of the knots, or the hair of his close friend that was also found at the scene? The judge set aside 3 weeks in December for the hearing. He could have found that there was no compelling evidence that new jurors would acquit and kept the men right where they were. Or he could have concluded the opposite, vacated their convictions and ordered new trials. If that happened, given the intense support for the West Memphis Three and the Attorney General's insistence that he believed the men to be guilty, verdicts in either direction were expected to be appealed. Supporters of the West Memphis Three were excited about the hearing ahead, but at best foresaw a lengthy battle. What we did not know is that in early August, Patrick Benka, along with Stephen Braga, had come up with a plan. Braga is in Washington, D.C., took the case pro bono. Benka is a Little Rock lawyer. Benka placed a call and they represented, by this point, Damian Eccles. Benka in Little Rock placed a call to the Attorney General, a law school classmate of his, suggesting that maybe they could have lunch. The Attorney General, McDaniel, agreed, and as Benka later told me, he asked, after they'd had some pleasant conversation, he asked if the state might be open to, quote, resolving the situation. Did I mention politics before? In the past few years, attitudes about the West Memphis case had changed dramatically in Arkansas. The new DNA findings had had an impact. So did the turnout of 4,000 people for the concert in Little Rock. So, I presume, did the defeat of former prosecutor and now Circuit Judge John Fogelman in his run for the state Supreme Court, despite backing by the State Bar Association and the Arkansas Trial Lawyers Association. There's also this. Attorney General Dustin McDaniel is widely expected to be the Democratic candidate for governor in the election 2 years from now. At his lunch with McDaniel, Benka outlined the idea of proposing an Alford plea, a plea in which defendants are allowed to plead guilty while maintaining that they are innocent. As you probably know, this is something that is usually done before a conviction. It almost never happens afterwards, and certainly not after almost 2 decades. Benka recalled that he was nervous in putting this request before the Attorney General. He said that the AG sat back in his chair, folded his arms, and said, "That's a big ask." But he also said that the Attorney General told him this was not his call to make. The decision, McDaniel told Benka, would be up to Scott Ellington, the local prosecuting attorney in that district. Suffices to say that Ellington went along with the ask. The state's only requirement was that any deal worked out had to include all the men. I'm sure everyone has heard by now that Jason Baldwin balked. When he was 16, prosecutors had offered not to seek the death penalty against him if he would implicate Eccles. Baldwin refused. He said it was a lie and he'd been raised better than that. The prosecutors then went into court asking his jury to sentence him to death. Baldwin said he didn't lie back then, and he wasn't about to lie now by taking a deal which, though it could free him, would require that he plead guilty. Ultimately, the all or nothingness of the state's position, which would have kept Eccles at risk of execution, persuaded Baldwin to change his mind. And so, on August 18th, the men were cuffed and shackled, placed in a van at their prisons, and driven to a jail in Jonesboro. The next morning, dressed in suits, they entered Laser's courtroom, where the agreements hammered out by the 3 teams of defense attorneys and attorneys for the estate, in consultation with the judge, were formalized. Here's what happened. First, Judge Laser granted a conditional order for a new trial. In it, he wrote, "The parties advised the court that they have agreed to a disposition of the petitions, and that if the court vacates the convictions, the defendants will enter guilty pleas pursuant to North Carolina v. Alford in order to resolve these cases." As to the negotiated pleas, he continued, the parties agree to the following conditions. A, the entry of guilty pleas to 3 counts of first-degree murder under the terms of Alford. B, the court sentences all 3 defendants to time served, followed by a 10-year term of suspended imposition of sentence. C, the immediate release of the